Welcome back to the Texas Appellate Law Podcast. I'm Jody Sanders.
And I'm Todd Smith.
And our guest today may be familiar to some of our listeners who go to different appellate CLEs across the state of Texas. He's not a Texas lawyer, but he's a familiar face. It is Arturo Ayala from Court Surety Bond Agency in California. Arturo, thanks for being here.
Yeah, thanks for inviting me and having me on, guys.
Well, our topic today is going to be Supersedeas, which I know is just every appellate attorney's favorite thing to deal with. But the truth is, it's such an important part because it's the thing that protects your client while we do what we do, which is figure out ways to attack a bad verdict, a bad judgment, and hope to get our client some relief. This keeps the judgment from being executed while that process is ongoing. So we're just kind of want to do a deep dive with Arturo today and talk about some of the practical things that we need to think about and just go with that. But first, why don't you just introduce yourself, give us your background, and kind of talk about how you got into what you're doing today?
Yeah, sure thing. Well, I'm from California, Southern California. I'm born and raised. And really the way I got into surety, I don't think anyone grows up thinking that they or dreaming that they want to become a surety bond agent or go in the surety industry. I certainly didn't. But that was when I was in college, going to a local state school, Cal State Fullerton in Orange County. I was lucky enough that a childhood friend of mine, he was actually working for CSBA. He had been working here for a few years. Dan Huckabee, which you guys know, and he's actually now the owner of CSBA. So at the time, I was going to school and he mentioned that CSBA was looking for a part-time entry level position and asked if I was interested. I was working, retail at the time, and I said, sure. I had no idea what a surety bond was. Worked here through college, graduated with a business finance degree. And when I graduated, I was offered a full-time position. And 24 years later, wow, here I am, and I love it.
So I just checked. We did have Dan back on the show way back in October of 2020, Jody.
Wow. So he was one of our first guests.
If you can believe that. He was early days for us, and we had a really great visit with Dan and went through a bunch of the process of getting Supersedeas bond. But we refer listeners back to that episode, of course. We're really happy to have you on the show because you're the guy that deals with the nuts and bolts. I mean, Dan now he's in the ivory tower. He's the owner and he's just writing all the checks or getting all the checks, I guess I should say. But no, and it's no secret that our podcast enjoys a really nice relationship with CSBA because you are, at full disclosure, one of our sponsors and have been from just about the very beginning. So we're, of course, grateful for that relationship. Jody mentioned that you would be a familiar face. I mean, CSBA does a great job of outreach among the appellate bar specifically. I can't think of an appellate conference I've been to in recent years where you and I think maybe one other person have been there exhibiting at a table and sponsoring something. And so it's a great relationship that the Texas bar has with CSBA, even though y'all are way out there in California. So thanks for doing that. And thanks for making yourself available to talk with us today. I know that, there are things that do change over time in the course of Supersedeas law, and those of us who aren't, so well educated on it though, or even those of us who are, need to hear about it over and over again. So we're reminded of it. So you went to work with CSBA and your position, you're up at, I think you're vice president now?
Correct. Yeah. So I started, like I said, entry-level position, typing bonds. Actually, CSBA has two divisions, one that does construction bonds for public works projects, construction companies, and then we have the court division. And so for the first, I'd say 10 years of my career at CSBA, I worked on the construction side, and then I had the opportunity to start working on the court side and really enjoyed it. And I was able to transition full-time into court and have been doing it now for the last, 13, 14 years, and was able to work myself up. I'm currently the vice president of the court division.
Are y'all writing construction bonds in Texas too, in addition to Supersedeas?
So for the construction side, that's a little bit more regional, more localized. So they really concentrate mostly in California. Whereas because of the nature of the court bonds, we are able to write those nationwide, Texas being a big state for us.
Makes sense. I ask that because so much of our state is just constantly under construction.
That's the truth. So, I mean, for the appellate attorney, our ideal world is where we kind of get involved before the trial. But the place where we start talking about bonds is pretty much right after the verdict, because that's the place where, okay, you kind of generally know now you've got someone who's on the winner side, someone who's on the loser side, and someone's going to get a judgment entered against them. And we're all trying to figure out what that looks like, but at least you recognize there's potential there. And if you come up on the side that's going to have to pay the judgment, it's time to have the conversation about superseding the judgment. And we've talked a lot on this podcast about different ways you can do that in Texas. But I think the reality is supersedeas bonds are some of the most common for big civil cases, at least. I know that some of the different cases you can do cash. So I'm an attorney. I recognize that it needs to be superseded. I've told my client that, but what happens when the client calls you? Like, how does the process work on your side? Because I'm familiar with the rules and getting it in place, but I don't know so much about your side. Walk us through that.
Yeah, sure thing. So generally obviously when a client reaches out or the attorney puts us in contact with the client, or, we have a conference call, they're in a tough spot, right? They either going to be facing a verdict, an inverse verdict, or it was just entered, and they're coming to us because they need to post a bond. And what we really try to do is try to outline the process for the client in that initial conversation in terms of, underwriting requirements, what it's going to take to put the bond in place, the timing that is going to take to put the bond in place, and the cost as well, estimated costs, right? So what we try to do is first understand, when does the bond need to be in place by? Then from there, we try to understand the client's financial wherewithal. With supersedeas bonds, the underwriting, what I tend to explain or compare it to, it's very similar to banking. It's a credit underwriting decision, but it's strictly a financial guarantee. So what we try to do is understand the client's financials more often than not, depending on the size of the judgment and the financial wherewithal of the client. Collateral may be required as a condition of approval. If collateral is required, then what we try to do is kind of understand the client's preference or the client's available assets that they may have to post as collateral. And then we go through the different pros and cons with each type of collateral. When we talk about collateral, I think most people probably think cash. And then naturally the next question is like, well, I could post cash with the court. Why would I post it with the surety company? Does it make sense, right? So we kind of try to understand, if the client does have cash, well, there's options out there that are available where they can invest the cash and earn interest while it's posted with the surety company that's above and beyond the bond premium that they would pay. Where I realize some courts do pay minimal interest or could pay, some don't. So it's just something to keep in mind. But cash is only one collateral option. There's probably 5 different types of collateral. Like another form would be, I'd say, irrevocable letter of credit, commonly referred to just as an ILOC or a lock from a bank. That's commonly accepted. But sometimes we have clients where they're real estate rich and cash poor. We have options where they could potentially post a piece of property as collateral. And then we also have some high net worth individuals that may have an existing life insurance policy. There's a surety company that we work with that could take a pledge of the cash value of life insurance as collateral. If someone has an existing brokerage account, that's another form of collateral that we could look into. Or a combination of all those, right? So we really just try to understand the client's financial wherewithal, their preference as to which assets they would be willing to tie up, and then go from there.
Well, you stole one of my questions, and I know that I asked Dan about this way back when, about the cash poor, land rich situation. But I'd like to kind of drill down on a couple of those things, because those are that becomes the next question that clients want to ask, is if I go through, say, this list with them of possible kinds of assets that could be pledged, pledging land, that my recollection is that can be a pretty involved process. It might even involve an appraisal. Can you just kind of tell me what kind of things y'all would want to know when you're trying to evaluate whether a land rich, cash poor client could maybe supersede with you all?
Yeah, sure thing. So I think with real estate, probably the first thing we would want to understand is the timing or the deadline of when the bond needs to be in place by, because that's a type of collateral that takes the longest to be put in place. It could take anywhere from, on average, I'd say 4 to 6 weeks, right? And because, like you mentioned, Todd, the process is pretty involved. So what we generally do is, so I guess just to back up and give you a little background on the marketplace, right? There's over 30, 35 surety companies that we work with and that underwrite supersedeas bonds. Out of those, there's really only one that considers taking real estate. So it's not a very common form of collateral. And when they do accept a piece of land, piece of property as collateral, they're very conservative. Last thing a surety company wants to do is own a piece of property. They're not in the real estate business.
Yeah.
So what they do is they'll do an initial evaluation on the property to see if it has sufficient equity as they view it to post as collateral. And they generally prefer residential properties that are free and clear. If they do have a small mortgage relative to the bond amount, they could consider it as well. And they could consider commercial properties. It's just, again, not very common. So once they do a preliminary review, they could generally get back to us within a couple days and give us a preliminary indication whether the property is acceptable. From there, then they do the due diligence, they do order an appraisal on the property, and then they do title searches, right, to make sure that there's not any other encumbrances besides, say, the first mortgage on it.
So it's kind of similar to applying for a mortgage.
Very similar, yeah. Except that they're a lot more conservative and they
True.
Yeah. So just to give you an example, like the way they kind of view things is they generally will take the market value of the property and they'll discount it anywhere between 30 to 50%.
Wow.
So, and if there's a mortgage on it, they'll generally add 10% to it. So then the difference then is what they would view as having as equity to post as collateral.
Well, let's carry that all the way through then. Let's say that a bond is approved with real estate as the collateral. The appeal goes up, the judgment stayed pending appeal. Appeal happens, and unfortunately, the judgment is affirmed. So then, I don't know that we really got into this when we talked to Dan so many years ago now. The uncomfortable part of this process is not just getting the bond. It's what happens after the judgment's affirmed, becomes final and unappealable, and then it's executable. The process here is, as I recall it, fortunately, I don't have to deal with this very often, is that, the judgment debtor is the first one that the judgment creditor is going to look to satisfy the judgment. But if they don't pay the bond, that's what the security is for, right? And so then the judgment creditor gets to execute on the bond. That's my memory of how this works. And so, and you all, though, y'all are connecting people. You're connecting the underwriter to the client. So y'all are not involved, are you, in that process when it comes down to the bond being executed on?
We're involved we're involved throughout. So let's just pick it up from there's the judgment's upheld, it's affirmed, and judgment debtor hasn't satisfied the judgment. So the judgment creditor files a claim on the bond. Generally, what happens is the surety companies will reach out to us and let us know, hey, we got this claim on this bond. And what we do is we reach out to the client and their attorney, because usually we're in contact with them, and obviously they know. Really what it comes down to is just asking our principal, the judgment debtor, hey, do you want to satisfy the judgment, or do you want the surety company to pay out on it? If the surety company pays out on it, depending on the type of collateral, like say if it's cash, then they just use the cash that they're holding. If there's a letter of credit that was posted with them, they'll just draw down on the letter of credit and satisfy it that way. If it's real estate, it really depends. With the surety company that takes real estate, what they do is, again, last thing they want to do is own a piece of property, right? So, but if that's the only asset that the judgment debtor has to be able to satisfy the judgment, they'll work with them, right? They'll ask them if that's what you want to, if like what we've had happen is the judgment debtor will ask the surety if they could refinance the property, take money out and use those funds to satisfy the judgment.
Right.
And since the surety company is in a first lien or possibly a second lien position, the surety company basically just signs off on it. And through escrow, then that judgment gets satisfied. Once it's satisfied, the surety company releases their lien on the property.
And the judgment, once it's satisfied, should be released also. That would take care of all the judgment debtor's obligations once the judgment's paid.
Correct, right. So, in this process, the surety company's legal department gets involved, and they're usually in contact with both parties' attorneys. So when the payment of the claim gets made, they'll generally ask for a release of the exoneration of the bond, release a claim on bond form at that time. So basically, their liability is completely exonerated, and so is the judgment debtors.
We have a rule provision in Texas that allows, when representing the appellees in a case where there's a money judgment that's been superseded, allows the appellee to ask the appellate court to render judgment against the surety if the judgment's affirmed. And that's something that I try to make a habit of asking for when I'm on the appellee side of that judgment creditor side. How does that factor into the process you just went through? Or there's maybe a distinction, or is there, between there being a judgment rendered against the surety and a claim on the bond? Is there any separation between those two that you can explain?
Not that I could think of. I would imagine that it'd probably be just the time that the surety company has to pay out under the bond. More often than not, I mean, when they, the bond's strictly a financial guarantee, right? So
Right.
if there's a claim, and it's still always the judgment debtor's obligation to satisfy the judgment. But if they don't, that's what the surety company is there to do. So,
Right.
So the judgment creditor, they'll get paid regardless. I think it would just be a matter of the timing that the surety company has to satisfy it.
Well, that's also why the court has to, on a motion, the court has to approve a bond or review. It can be asked to review a bond. And I've seen it happen where some judgment creditors have questioned the AM Best rating on a surety. And, you want to have a rating above a certain number of stars. I forget what it is. I think, 4 is a good score. I don't know.
Right. So it's you're exactly correct. It's the AM Best rating. You want to make sure that it's a A-rated surety that's issuing the bond. And if it's a federal case, then you have to make sure that it's Treasury listed. And there's a Treasury listing that comes out every year, and it basically outlines all the sureties that are approved to issue bonds to the federal government.
Yeah, I'd forgotten about that, actually. And just one more little sort of anecdotal thing. You don't have to be necessarily a surety to write a supersedeas bond, is my recollection. I've seen a few instances where there's been sort of almost like a personal bond, like you got
or like
personal
some
guarantee.
intra-company guarantees, kind of a deal.
Yeah.
Which I've also seen challenged, but
I would never be comfortable with that, because I would want my client to have the assurance of having an AM Best rated company behind them. Because, I mean, if you pledge the collateral and ultimately that's where all your assets are, you want the judgment to get paid through the surety. And if the surety somehow messes up, that can be a real mess. Thankfully, not something I've had to litigate, fortunately, and I hope I never do. But it does give a lot of assurance, I think, to judgment debtors when you've got the backing of a company that, even though it's painful, especially if you're talking about them valuing real estate at up to 50% discount. The reason for that is because, of course, they've got to have some assurance that they're going to get their investment back, right? So it's a painful process, but there is a lot to be said for the peace of mind that comes with having the backing of a well-approved surety.
Yeah, and to your point, Todd, as well, as far as, a motion of contesting, say, the bond or the validity of the bond, one thing that we always try to suggest to attorneys and their clients, as well as before we actually finalize the bond, is run it through the other party. Make sure that there's any issues, maybe there's something on the language or a specific thing that they want added, we could certainly take that into consideration. And that way, once it's filed and posted, then, they're not going to contest it.
Yeah, that's a great point. I think, we have pretty, in our state courts, as you know, we have pretty clear-cut rules for what's required to bond a judgment. It's a little more flexible in federal court, although the default is it's actually not more flexible in the end because you don't get the benefit of the net worth caps and so forth in federal court here.
There's
So
less
it's kind of
guidelines, maybe.
yeah. No, I totally lost my point.
Sorry.
No, it's okay. This is why we have editors, Arturo. This is indicative of my state of mind right now. Sorry, guys. What was my question that I just asked? It was more of a comment about.
Yeah, you're kind of talking about.
Here we go. All right, we can pick back up with editing here. But your answer gets into something that I preach, which is that even though our rules in state court are fairly clear cut on what you need to do to get a judgment bonded, and they do allow for some flexibility, it's still a good idea to have that conversation with opposing counsel and say, look, you got this judgment. Congratulations. We intend to appeal. We're looking to supersede the judgment. Here's what we're thinking. Do you have any feedback? And I think you get a lot of different answers to that question depending on the situation. There are a lot of lawyers who would say, nope, you better do it right or I'm going to challenge you at every stage. And that happens.
Mm-hmm.
Or you have some who understand, and people who've been through this process, maybe representing a client also, who the main objective here really for both sides is from the debtor side, let's keep the creditor from coming after what I have. And on the creditor side, it's want to secure the value of my judgment. And the flexibility in Texas supersedeas law might be something that actually contributes to friction there, because then we get into satellite litigation issues like net worth. And that opens up a whole nother can of worms when you have to go there. In most instances where you've got somebody who has the wherewithal, the financial backing, the security of a bond, I think really is a really nice thing to have, because it just removes all doubt about whether the judgment is superseded. So, but my basic point is, you raise that good point about talk to the other side, because I think, and we've advocated that over and over again and over the years on this show, if in doubt, pick up the phone and talk to your opposing counsel, because you'd be surprised what they might agree to.
Yeah.
I want to talk a little more though, Jody, I don't want to cut you off if you've got a line of questioning to get into.
Well, it's just kind of related to what we're talking about. So if you're going to switch topics.
No.
Okay.
Yeah, do it now. Ask now, and we'll clear this up in editing.
From your perspective, Arturo, does it really matter much if it's a federal versus a state judgment in terms of how you underwrite the bond and the things you look at?
No, not from the surety company's perspective. They don't really get into really the merits of the case or the merits of the appeal. Right. For them, they just view it strictly as a financial guarantee because, as you guys know, more often than not, those are not successful. So they do view them as high risk, whether it's on a federal court or state court. They really just go off of the financials.
I wanted to also loop back to the irrevocable letter of credit, because that's something that you do see that's used, as you point out. That generally, I know you're not part of that banking relationship, but it seems like that's going to be mostly people who have a really strong lending relationship with a bank already in place. Is that accurate?
That is accurate. What I always suggest to clients when they're thinking about going the letter of credit route is first reach out to the bank you have the best working relationship with, and ask them, what it would take to get a letter of credit in place. That's the best place to start. And then from there, usually banks have different ways of underwriting and securing letters of credit. Sorry, can we strike that? I think I was just going the wrong.
Yeah, absolutely.
Sure.
Can you repeat the question, Todd? I'm sorry.
Oh, no, it's okay. The presumption is, at least my presumption is, that there's already a strong banking relationship there, but that's not something that CSBA gets in the middle of. You're basically saying exactly what, to follow up with that thought, is talk to the lender that you've got a strong banking relationship with and see whether, if you don't have the funds on hand currently, are they going to be willing to extend you credit in such a way that you could use it as collateral.
Right. Yeah. That's the best place to start, like I mentioned, and where we come in, or where the value, I would say, of a surety agent comes in is, like I mentioned earlier, most surety companies, the 30 plus surety companies that we work with, they all accept letters of credit from banks, right? But then what they end up doing then is they underwrite the bank. Not all banks are acceptable to surety companies. Your large national banks, yes, any surety company will take a letter of credit from them. But we have clients that work with smaller regional banks, smaller community banks. So then it's the agent's job to make sure that they find a surety company that will accept a letter of credit from that particular bank. And the banking issues that we dealt with a couple years ago with a couple banks going down, right? Companies did tighten up on which banks they accept letters of credit from now.
Yeah, that's one of those things that from our side we don't necessarily think about. You just assume, well, if your client can get a letter of credit from their bank, it should work. But I guess it does depend on what the bank is as to whether or not it's going to be acceptable collateral.
Right.
And that's also one of the things kind of figuring into the overall cost of the bond is if you're going to have a letter of credit, what are the fees the bank is going to charge, which are separate and apart from a bond premium.
Well, and that's where I was going next was, the takeaways I think so far from our conversation are, one, act right away. If the judgment's about to be signed and it's not too early to start talking to someone like CSBA. Two, talk to your opposing counsel about what might be acceptable to them, because that might affect the course of action you take from among all the options that you've got here. And yes, you can do a cash deposit in lieu of bond, and there are certain advantages to that, or you might even be able to pledge securities or other assets directly. But if going through a company like CSBA is the correct choice, then you want to have those conversations right away. Third, and which we really haven't talked about, we're kind of segueing into, is what should judgment debtors expect in terms of a bond premium, and how does that work? Is it renewable annually? What's the cost of acquiring the security?
Yeah, so the cost, I would say the premium rates vary. There's a wide range. I would say they go anywhere from 0.25% all the way up to 4%, and anywhere in between. And there's a couple factors that play into the premium rate that the client would pay. One would have to be whether they qualify for collateral or not, right? If it's a large publicly traded company, insurer, a bank, they more often than not, they qualify without collateral. Then if it is collateral, then the type of collateral that's used. For example, if they're using cash, right, that's going to be more, I'd say, depending on the bond amount, but on average, I'd say 1%. The other end of the spectrum, if they're using real estate, is surety. Like I said, there's only one surety company that takes real estate. They charge 4%. So it's a lot higher. And then also the third thing that surety companies take into account when they're coming up with the premium rate is the bond size, the bond amount. The way surety bonds or supersedeas bonds specifically work is the higher the bond amount, generally the lower the premium rate that the surety company will charge. So it really depends on the type of collateral, the size of the judgment, and whether collateral would be required or not. That's that's how the surety companies will then come up with the premium rate.
Yeah, and I did wonder about that. The types of judgment debtors who would not be required to give collateral. I mean, that's not going to be me or Jody individually. It's not going to be maybe even our law firms. Well, not my law firm, maybe Jody's.
I hope we don't have to find out.
Let's not find out. Are we really talking about more in the vein of either publicly traded companies or maybe closely held companies with very, very, very healthy balance sheets that would meet that criteria and qualify without collateral?
Right. Yeah. Generally, where we've seen or where we've been successful in getting approvals without collateral have been publicly traded companies, banks, insurers, or very large privately held companies with substantial liquidity relative to the bond amount. That's really what the surety companies look for is liquidity it's lines of credit, if they have open lines of credit and available. The way to think about it is a surety company, in order for them to approve a bond without collateral, they have to be certain that the judgment debtor is going to be able to easily satisfy the judgment in a worst case scenario if the judgment's affirmed. Not just now, but they have to forecast 2, maybe 3 years from now, right? When the PO is actually going to be done. So that's what makes it hard for them to project out. It depends on the type of industry that the judgment debtor is in as well. So all that goes into play.
Yeah. And I see your point you made at the beginning about, cash collateral, you might actually do better and should, based on what you said, the typical premium is at 1%. If you fork the cash over to the surety and then it's invested in something that's going to actually bring back some money, because depositing money into the court's registry isn't going to bring you squat unless you specifically ask for it to be deposited into an interest-bearing account. And even then, interest-bearing accounts are terrible. So that's, if I take nothing else away from this conversation today, it's a good reminder that sure, okay, you could deposit the cash, but at the end of the day, do you want to have your $1 million plus whatever interest, or you want to just get your $1 million back or get $0 back if you lose? But makes a lot of sense if you're talking about those kinds of dollars to try and have the money, doing some work in the background.
Yeah. I mean, over the last several years, just because of where the interest environment has been, it's been a very, I'd say, popular option for clients to take advantage of those options that we have available where they could earn interest on the cash. Even now, I mean, interest rates have gone down, but it's above and beyond what they've paid for the bond premium.
Yeah, that's nice. And I'm not sure that I heard you answer what the second part of my initial question about premiums was. Are they renewable? Is it as an annual fee, or is it a one-time fee, or how does this work?
Yeah, that's a good question. So the premiums are annual. The surety companies, generally what they do is that they'll charge the initial premium when the bond is issued, and then at the renewal, they'll charge for the full year as well. The first years premiums are generally considered fully earned once the bond's issued, but any renewal premiums, those are prorated if the bond is, say, released, exonerated 3 months into the renewal period, then the surety company will issue a prorated return premium back to the client.
Yeah, that's good to know too. If it's returned, that means is that affected by the result, or is it just a matter of the timing?
It's just a matter of the timing, right? Of when the bond's actually exonerated, whether the judgment's affirmed or upheld, or when if it's affirmed and the surety pays out on the claim, bond's exonerated, it's based on that date. It's really the surety company, they base it based on the date the bond is exonerated.
This is probably a good time to bring up an important difference between federal and state practice in Texas, which is the recoverability of bond premiums as a cost.
Yep. That was actually something I have on my list to talk about. Where Texas unfortunately lags behind.
Well, it depends on which side of the issue you're on, whether it's fortunate or unfortunate. Just as a setup, basically in federal court, surety premium for a supersedeas bond, if you went on appeal and you put up the bond, then you can seek that cost back from the appellate, which it can be a bit of a hammer in negotiations, depending on the case. A potential settlement on appeal negotiations. State courts, as Jody has suggested, we do not have that rule. So the bond is, the cost of the bond is just a cost of doing business for the appellant, the judgment debtor, and they don't get to recover that. And so that's a little beyond your purview, Arturo, but since we're on our super nerdy topic of the day, it's worth pointing out to those who are listening.
I don't know. My humble opinion is that if Texas made the bond premiums recoverable as a court cost, it would end a lot of satellite litigation about some of these supersedeas issues, and parties might agree to some arrangements a little more readily than we do perhaps now.
No, that's a great point. The Supreme Court I don't know if it had to be a legislative change to do this.
I think it would, because court costs are typically statutory.
Yeah. So I guess, maybe it's a future initiative for the Texas legislature to take up. I was going to say, our Supreme Court has been in the process for 2 decades of sort of federalizing our rules in some way, that loosely speaking, not like some states actually adopt basically the federal rules verbatim. We don't do that, but that's an interesting point is, we do see a ton of litigation, satellite litigation over bond issues. Anytime you file an affidavit of net worth, you're pretty much going to draw a contest, which is going to mean hearings, evidence, it can be a whole mini trial.
Appeal.
Yeah,
mini trial and mini appeal.
No, that's exactly right. I've filed full-on briefs in the appellate court just on the issue of net worth. While it's interesting, you got to be kind of a little twisted to find it interesting, frankly.
You'd have to host an appellate podcast or something.
Yeah, you must be a podcast host if you find this kind of stuff interesting. But yeah, we're starting to go a little far afield, Arturo. You're doing great in indulging us on this little side topic here. But well, I guess, we're starting to kind of get toward the end of our time together. Did you have any parting thoughts? We usually ask our guests for a tip or a war story, and I know you've probably got a lot of tips. And if there's any that you haven't covered already in our talk today, we'd sure love to hear them.
Sure. So I was thinking about that, but as far as war stories, I think I have quite a few.
I bet.
I can imagine.
I was trying to think of the common theme, and there is actually a common theme on most of them. And it's kind of been, we touched on it today, and it's with time. It's the deadline that judgment debtors face on having a bond in place. So one of the main tips that I think I would probably give, the main tip would be try to get started on looking into supersedeas bond as soon as possible. Right. Mm-hmm. Don't need to wait till the judgment is entered, the verdict's entered. If you have an inclination that, an adverse judgment, adverse verdicts coming in, reach out to a surety professional, get the process started. I always get asked, when's the right time? How soon? I don't think it's ever too early to reach out and at least know what the options are. Mm-hmm. There's generally no cost to the judgment debtor besides their time. And at least they know where they stand. They know we could work on getting a preliminary approval in place for them and up to getting ready to, have the bond issued. And then if for some reason they don't end up needing the bond, they don't want to appeal, whatever the case may be, then we just close our file. We let the surety company know, close our file, and that's it. But at least that way they know where they stand. They know what the cost is going to be. They know what it's going to take to get the bond in place.
Yeah. No, that's great advice, and certainly one that I'll recommend that my clients take to heart. So if you don't know about CSBA, you guys have a lot of great resources on your website, a lot of how-to and some checklists and things like that y'all put out that are just really good resources for Texas lawyers specifically. And, if you see Arturo hanging out at the next advanced appellate seminar or the UT seminar in the summer, be sure and say hello and tell him thanks for what he does, because it certainly makes our lives easier. When clients need them, they really need them. And I'd hate to sound like an advertisement, but maybe that's your new slogan, Arturo. Arturo Ayala, when clients need them, they really need them. But no, seriously, hey, thanks for spending the time with us today. We're super happy to have you on and talk about a topic that doesn't really get enough attention, I think, in the day-to-day lives of appellate lawyers, but it's a critical one. And so what you have talked about today is super informative and I think helpful to our listeners.
I know. Thanks again for inviting me, guys. I really appreciate it and appreciate what you guys do.
We appreciate that.